5 seconds to go. Start. In the case at hand, it is clear crystal that on the basis of a complaint made by a member of the Legislative Assembly, an inquiry was directed to be held. It has been innocuously stated that the complaint was relating to illegal section on the ground that the appellant did not possess the requisite qualification and was appointed to the post of chest therapist. The report that was submitted by the Cabinet Vigilance Department eloquently states about the conduct and character of the appellant. The stand taken in the counter affidavit indicates about the behavior of the appellant. It is also noticeable that the authorities, after issuing the notice to show cause and obtaining a reply from the delinquent employee, did not supply the documents. Be that as it may, no regular inquiry was held and he was visited with the punishment of dismissal. It is well settled in law that if an ex parte inquiry is held behind the back of the delinquent employee, there are stigmatic remarks that would constitute foundation and note the motive. Therefore, when the inquiry commenced and thereafter without framing of charges or without holding an inquiry, the delinquent employee was dismissed, there is clear violation of principles of natural justice. It cannot be equated with a situation of dropping of the disciplinary proceedings and passing an order of termination simpliciter. In that event, it would have been motive and could not have travelled to the realm of the foundation. We may hasten to add that had the appellant would have been visited with minor punishment, the matter possibly would have been totally different. It is also not the case that he was terminated solely on the ground of earlier punishment. In fact, he continued in service thereafter, as the report would reflect that there are many allegations subsequent to the imposition of punishment relating to his conduct, misbehavior, and disobedience. The Vigilance Department, in fact, had conducted an inquiry behind the back of the appellant. The stigma has been cast in view of the report received by the Central Vigilance Commission, which was ex parte, and when that was put to the delinquent employee, holding of a regular inquiry was imperative. It was not an inquiry only to find out that he did not possess the requisite qualification. Had that been so, the matter would have been altogether different. The allegations in the report of the Vigilance Department pertain to his misbehavior, conduct, and his dealing with the officers, and the same also gets accentuated by the stand taken in the counter affidavit. Thus, by no stretch of imagination, it can be accepted that it is termination simpliciter. The division bench has expressed the view that no departmental inquiry was required to be held, as it was only an inquiry to find out the necessary qualification for the post of chest therapist. Had the factual score been so, the said analysis would have been treated as correct, but unfortunately, the exposition of factual metrics is absolutely different. Stop.